Well, Mr. Perry, you are still on your feet, and with good reason, because Lord Reed has a question for you.
Right, thank you.
I appreciate this isn't how you put your case, Mr. Perry, but one view that might be open to us is that while the convention, as drafted back in whenever it was,
84.
84,
Yeah.
was drafted according to traditional ideas about state responsibility and focused on state actors. It's one of these treaties that has evolved in its interpretation over the decades, and particularly in the case law of the CAT, one can see an evolution from, say, the early GBR case through ELMI to SS, and the idea of what is a public official or acting in an official capacity becoming broader in response to the sort of situations that have emerged in places like Rwanda, Afghanistan, and so forth. Now, the point I want to ask you about is this. And of course, the UK legislation passed not very long after the convention gives effect to it. Now, the question is this. If it's one of these treaties which has had an evolving meaning, we're concerned here with alleged offences committed in 1990. So should we be looking at how the treaty has evolved in more recent times, or should we be focusing on how it was understood at that time, particularly in order to avoid problems of retroactivity?
Well, my Lord, what I would say in relation to that, the first point is, my Lord, I accept it is an ever-speaking instrument. The second point I would make, Lord, is in accordance with ordinary principles of customary international law, it would be declaring what the law was then in terms of in terms of the Jus Cogens rule, because for example, just to give an example, it's not an authority that's in the bundles, but your Lordship may recall the piracy case in the Privy Council in 1932, when the point for the Privy Council to decide on an appeal from Hong Kong was whether piracy involved robbery at sea. And the Privy Council had no problem in declaring that it had always been the case that it didn't involve robbery at sea, even though there had been some indications in some of the case law during the 19th century that was an ingredient of the offence.
Yeah. Well, I quite see that if you're talking about a common law offence, I mean, marital rape would be another illustration.
That's another.
That's one thing. But here we're not dealing with a common law offence. We're dealing with legislation giving effect to an international treaty, and the treaty, as you say, is an ever-speaking instrument.
Yes.
And if you might, I don't think you accept the premise that its meaning in this respect has changed materially since it was first entered into. But if one were to accept that premise, then I wonder whether you can look at how meaning has evolved subsequent to the offences we're concerned with, or alleged offences.
Well, my Lord, it may not be a precise analogy, but I have in mind that the type of authorities decided by the House of Lords of committing assaults over the telephone under the Offences Against the Person Act 1861 on the basis that the legislature had not had in mind the possibility. Now, it may be that that's not a precise analogy, because it's just the means by which the threat is conveyed rather than the status of the perpetrator. But, my Lord, what I would submit is that the court can declare today what is today and was the case. An example of that, my Lord, I think, is Lord Millet in Pinochet. When Lord Millet was looking at the offence in Pinochet, he did not accept the conclusion reached by the majority, including principally Lord Hope, that the cut-off point was the date on which Section 134 came into effect. Lord Millet took the view that it had been a crime in international law even prior to that date, and the English courts or the United Kingdom courts had jurisdiction. And we would submit, Lord, that there is a great deal of, we don't need to sort of re-argue that, but we would submit there's a great deal of force in that view because of the nature of the peremptory norm and the obligation that it imposes in international law. Your Lordship is right that we haven't put our case on that basis, because we submit that the materials demonstrates what was the position at the time the convention came into force.
Yes. Thank you.
Thank you very much, my Lord. And, my Lord, just finally, we are collating some of the case materials for the court. The indictment, which conventionally just alleges torture, but there is also a case summary and some other materials in relation to the allegations, and if I may, we provide them to the court tomorrow, if that's convenient.
Yes,
Thank you very much. Thank you.
I think there are no further questions to throw at you, Mr. Perry.
Thank you very much, lady. Thank you.
Mr. Rogers? Mr. Swarrock?
We have 5 main points to make, but there is one overarching point, and it is this. The consideration that should guide this court in interpreting Article 1 of UNCAT can be summarised in 2 words: avoiding impunity. And in the 5 points that I will come on to make, we will develop that. First point, the importance of this case. This case has far-reaching consequences beyond the criminal proceedings from which this particular appeal arises. The specific question is the meaning of the term person acting in official capacity in Article 1 of UNCAT. In the context of the facts of this case, the broader question is whether and in what circumstances the definition of torture in UNCAT applies to non-state actors who commit atrocities in armed conflict situations, and consequently whether and in what circumstances such persons are subject to the universal jurisdiction framework of UNCAT. Put another way, the issue at stake is whether under international law there is to be a safe haven for such persons. The decision of this court on those matters will of course be binding in the UK, but the decision of this court will also carry considerable weight across the world in other jurisdictions where these issues arise. The second point, the interpretation of Article 1 must be guided by the object and purpose of UNCAT, which in practical terms means adopting an interpretation that it avoids impunity for non-state actors. The primary rule of interpretation of treaties is that set out in Article 31.1 of the Vienna Convention on the Law of Treaties. That is, that a treaty must be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. It is striking that the appellant's oral submissions failed to engage with object and purpose, but instead jumped straight to travaux préparatoires, which under the Vienna Convention is a secondary means of interpretation. It is common ground between the respondents and the appellants that the object and purpose of UNCAT is what is set out in the preamble. That is, to make more effective the struggle against torture. The object and purpose of UNCAT, that object and purpose, is achieved through the framework of universal jurisdiction, the obligation in particular that we see in Article 7, but also elsewhere in UNCAT, to prosecute or extradite an alleged torturer where that person is found or is present within the territory of the state, regardless of where the alleged torture took place and regardless of the nationality of the torturer or the victim. I would like to, at this stage, just refer the court to the ICJ's decision in Belgium versus Senegal. That is at tab 15 of Intervenors Bundle 1, page 290. In this case, the question was whether Senegal was in breach of its obligation under UNCAT to prosecute Hissène Habré, the former president of Chad, for alleged acts of torture committed whilst he was president. The case was brought in the ICJ by Belgium, and Senegal argued as a preliminary point that Belgium did not have standing to bring this case because it said Belgium has absolutely no link with Senegal or with Hissène Habré or with the alleged acts of torture. The ICJ rejected that argument, holding that the obligations in UNCAT are obligations erga omnes. They are owed by each state party to UNCAT to each other state party, regardless of any special interest. And I'd just like to go to paragraph 68, where the court fleshes out the concepts of object and purpose. As stated in its preamble...
Sorry, page?
Sorry, this is page 320.
Thank you.
As stated in its preamble, the object and purpose of the Convention is to make more effective the struggle against torture throughout the world. The state parties to the Convention have a common interest to ensure, in view of their shared values, that acts of torture are prevented and that if they occur, their authors do not enjoy impunity. The obligations of a party to conduct a preliminary inquiry into the facts and to submit the case to its competent authorities for prosecution are triggered by the presence of the alleged offender in its territory, regardless of the nationality of the offender or the victims, or the place where the offence has occurred. All the other state parties have a common interest in compliance with these obligations by the state in whose territory the alleged offender is present. And it's that common interest that gives rise to the erga omnes obligation, which is what they hold later on in that paragraph. And also, I'd like to refer to paragraph 74 at page 322. At the beginning of paragraph 74, again, the court refers to the obligations to prosecute or extradite in the treaty. And then at the end of paragraph 74, it says this: the purpose of all of these obligations is to enable proceedings to be brought against the suspect in the absence of his extradition, and to achieve the object and purpose of the convention, which is to make more effective the struggle against torture by avoiding impunity for the perpetrators of such acts. So we say the court in this case must adopt an interpretation that avoids impunity. The possibility of impunity can arise where, for example, a de jure government is unwilling to prosecute torturers, most obviously because the government itself is torturing. For example, the government of President Pinochet in Chile in the 1970s. That would be an example where the ordinary machinery of government could not be expected to prosecute the torturers, and in which case one would expect the framework of universal jurisdiction to kick in so that wherever those torturers travel in the world, there is no safe haven. But the possibility of impunity may also arise where a government is unable to act. For example, where a rebel group seeking to oppose or depose a government exercises de facto control over a civilian population within that state. In order to avoid impunity in such a situation, again, one would expect the obligations of universal jurisdiction to be engaged so that there can be no safe haven for individuals who torture on behalf of such entities. Our third point: it is absolutely essential for this court to pin down the appellant's precise case and to scrutinise it rigorously. The appellant's case has shifted frequently and in material respects. In the Court of Appeal, the appellant argued the test for official capacity was whether a person was acting for the government of a recognised state. The reference for that is from the Court of Appeal's judgment, where the Court of Appeal summarises the case being put, and that is core volume MS 217, paragraph 10. In the written case for this appeal, the appellant said that her test was official capacity depends on whether there is, quote, the government of a state, capital G, capital S. And it was said that for these purposes, there was no need for the state to be recognised. We understand that at least the written case, it was being said that that meant state as a matter of international law. During oral submissions yesterday, the appellant appeared to accept, in response to a question from Lord Lloyd-Jones, that there needs to be the recognised legitimate government of a state. So that's a third iteration of the test. No need for a recognised state, but they were saying there has to be a recognised government. But then later on in the morning, the appellant appeared to drop altogether the requirement for there to be any government at all, and they rested their case on the need simply for there to be somebody acting on behalf of a state. There is a short forensic point here, which is any court should be wary of accepting a case that changes so frequently, but there is a more fundamental point. the court needs to understand what that case is in order to test it and in order to be satisfied as to what the ramifications are of the test it is being asked to accept. The court should not blindly accept any formulation simply being with the word, well, it doesn't really arise on these facts as to whether there was a state or not. As I say, we understand their case, as finely put at the end of yesterday, to be official capacity, or a person acting in an official capacity, means a person acting for a state, meaning a state as a matter of international law, an entity that has achieved statehood as a matter of international law. If the appellant is not saying that, and if the appellant is saying, well, we're not suggesting it has to be a state as a matter of international law, then that poses some, we say, insurmountable problems for the appellant. First, it would mean they are in fact accepting that it is sufficient for there to be some kind of de facto entity, which begs the question, why should their formulation, what precisely is the de facto entity they're talking about, and how is it different to the de facto entity that's being talked about on this side of the room? But it also creates problems because a very large amount of their case, for example, in relation to travaux préparatoires, as we understood it, was based on the proposition that the intention was for the treaty to be applied to states as a matter of international law. So if they're backing away from that, it nullifies a lot of what has been said by them. Fourth, and in any event, the appellant's case is wholly inconsistent with the object and purpose of UNCAT. It would certainly not be effective to avoid impunity. The point can be illustrated with reference to the example that we give of ISIS. We give three conflict situations, ISIS in Iraq/Syria, Boko Haram in Nigeria, and the Taliban in Afghanistan. But I just want to pick up one of those, and that is ISIS. In paragraph 10 of our submissions, we have given examples of atrocities committed by ISIS, and a lot of this is well documented in the media. But I would like to pick up just one of the reports that we refer to and give a couple of examples. Please, could the court turn to Intervenors Bundle 2, tab 37. This is page 553 to start with. Page 553 to start with. This is a report by the UN Human Rights Council. It's a report of the Independent International Commission of Inquiry on living under ISIS in Syria. And it's based on evidence and investigation and witness statements. But I just want to pick up two examples of acts by ISIS. The first is at page 559, paragraph 38. This talks about ISIS detention centres. ISIS has set up detention centres in former government prisons, military bases, hospitals, schools, and in private houses. Former detainees described being beaten, whipped, electrocuted, and suspended by their arms from walls or the ceiling. Witnesses to public executions remarked that the victims often bore signs of prior beatings. Detainees are held in dirty and overcrowded cells. Many spent long periods of time in handcuffs. Detainees interviewed stated that neither they nor their cellmates received medical treatment. And a second example over the page, at page 560, violations against women. At paragraph 48, first sentence, ISIS regulations dictate what women must wear, with whom they may socialise, and where they may work. then paragraph 49, ISIS's rules exacerbate the subordinate role of women in society, reinforcing patriarchal attitudes. Failure to abide by these rules is punishable by lashing. Punishments may be carried out by the Al-Hizbah morality police, but increasingly they are the responsibility of the all-female brigade Al-Khanza, which assists in monitoring adherence to dress codes and enforcing punishments. The acts committed by ISIS that I have just outlined would, on the appellant's case, on analysis, not come within the definition of torture in UNCAT. I should add, I've just picked two examples. I've spared the court a lot of the more gruesome details that we see in these documents.
Your paragraph 8, which we needn't turn up, explains that ISIS worked fast to restore essential services, establish basic governance, repaired water, electricity and road infrastructure, set up fuel distribution points, etc. So there was quite, on this basis, there was quite a big area of administrative authority being exercised over the area.
Yes, my lord, subject to this, it's the amount of territory that ISIS controlled fluctuated rapidly over a very short time, as did the population that they controlled, as did the extent and degree of those services. It varied according to which part of the territory you were looking at. The submission I'm making at the moment, and I can see it could be said there are distinctions on the facts from this case. The point I want to make at the moment is testing the appellant's case. And we are saying the submission is a short one, even allowing for the degree of these functions that we set out in our paragraph 8, ISIS is still not a state as a matter of international law. And that is the very simple point.
Okay, thank you.
And that simple point is made in our submissions at paragraph 39, and it is also made in the article at tab 20 of the intervener's bundle. So may I ask the court just to turn that up, please? This is an article that was written, this is tab 20, page 401, is the beginning. This article was written in 2017, that is towards the end of the ISIS ascendancy. And the very short point is at page 404 at the very top. Statehood is not a kind of reward that the international community bestows upon worthy entities. Rather, it is a status that significantly depends on criteria that should be assessed from a legal perspective. The need for scientific attention on this question is proved by the growing academic literature on ISIS's statehood, especially thanks to scholars from civil law systems, although so far no scholar has supported the idea that ISIS has even ever been a state, though there are different opinions about whether certain criteria are fulfilled, but that is the nub of it. If official capacity in the Torture Convention means someone acting on behalf of a state and as a matter of international law, then it excludes ISIS. And I just want to turn briefly to paragraphs 407 to 410 of this article. I'm not going to read out from it, but I'd just like the court to read it, because the point it makes is this. It says the question of whether a state is or is not, or an entity is or is not a state as a matter of international law, is an extremely complex one. The author here identifies a number of theories and tests. At the top of 408, he refers to what's called the 1933 Montevideo Convention, which is also cited in the appellant's submissions, which sets out a fourfold test: a permanent population, a defined territory, government, and capacity to enter relations. In the next para, he talks about what's called the constitutive theory. In other words, a state is not a state unless it's recognized as such by other states. he says, and this may well be right, that is probably not a theory that is supported by most commentators today. Then he talks about another test, which is what he calls the fact test, where the question is whether an entity is characterized by a government able to rule effectively and independently over a permanent population settled in a defined territory. And that's the test he then applies to ISIS. And he basically says, look, in circumstances where ISIS's control has varied and fluctuated so rapidly in such a short period of time, it is not a state. The other point, though, that emerges is if the court was to introduce this test into the Torture Convention, it would be introducing a whole series of complexities. And we say the very nature of these complexities makes it unlikely that the question of official capacity depends upon whether an entity is a state as a matter of international law. Fifth point, still sticking with the ISIS example. If we are right that on the appellant's case, members of ISIS and their acts would not fall within official capacity, it also follows that wherever those persons go in the world, wherever they travel, there would be a safe haven for them as a matter of the UN Convention against torture. They would not be caught by the universal jurisdiction obligation to prosecute or extradite in UNCAT. The scenario I am raising is not a fanciful one. We have given some statistics in our submissions on this point, but just in summary, this is paragraphs 11 to 13 of our submissions. A 2017 study estimated that 40,000 foreign nationals had travelled from 110 countries to fight in Iraq and Syria. And of those, it was estimated 5,600 have left subsequently to return to 33 different countries. The question mark is what has happened to the others to the extent that they have survived the conflict. Where are they? In February 2019, the UK government assessed 900 UK nationals had travelled to the area to fight, of whom 20% had been killed, 40% had returned to UK, and 40% are, quote, somewhere in the region. The reference for that document is IB2, Intervenors Bundle 2, tab 31, page 497. It has not been suggested by the appellant that any members of ISIS, to take this example, would be subject to an obligation to prosecute or extradite under any other instrument of international law. At most, they refer to domestic legislation. They refer to the International Criminal Courts Act and said there may be a basis to prosecute for torture under that act. There may be, I don't dispute that, but that is not relevant when one is interpreting an international treaty. The question comes down to what I said at the beginning. How is this court going to avoid impunity under this international treaty? It is not an answer to that question to say, well, this country, this one of 166 state parties, has a particular statute that might well avoid impunity. So in summary and in conclusion, the court must adopt an interpretation of Article 1, which is guided by the object and purpose to make more effective the struggle against torture and specifically to avoid impunity. That means, and that can only mean, rejecting the appellant's case. Whatever other test the court might adopt, we say it must follow that the court has to reject the appellant's case. And finally, we say that the respondent's case as formulated in oral submissions earlier this morning, is much more consistent with the object and purpose of the Torture Convention and with the overriding consideration of avoiding impunity.
But what is the test that you would suggest?
Well, we say...
Be adopted, because you will accept that however desirable no safe haven, no impunity for wicked people should be, there are some undoubtedly very wicked people who are not caught by UNCAT.
Yes.
You do accept that, I take it.
Absolutely. There is a perpetrator requirement in the treaty.
Yes.
And meaning has to be given to that. Put another way, a line has to be drawn somewhere.
And where would you draw, how would you draw that line?
We first of all, in terms of this case, we would draw the line by adopting the test that was formulated this morning, which was where a non-state actor who seeks to depose a government exercises de facto authority over a civilian population in an area in which they operate. We would say that the Torture Convention and the concept of official capacity should at least cover that situation. I use the word...
An area in which they operate as opposed to an area which they control,
Yes.
that's actually wider than the Court of Appeals.
It is wider because the Court of Appeal used the concept of territory, controlling territory.
So, for example, the IRA kneecapping people would fall within your definition?
Lord, no, it would not, because they would not be exercising... There is a distinction, we say, between kneecapping an individual, exercising authority over a particular individual, and exercising authority over a civilian population. It's the magnitude, the civilian population that engages official capacity. And just on the point about territory, we give another example in our material, which is the example of the Taliban post-2003. And there's a particular study that we cite which makes the point that although there is a central government in Kabul, the Taliban model since 2003 has been, in certain cases, it has tried to exercise control over territory, but in a number of other cases, it has exercised what is described as a shadow government. It has not controlled territory, rather it has, through fear and intimidation, it has managed to impose judges and other officials within administrations in different parts of the country. So that would be an example of an entity exercising what are clearly governmental functions without necessarily controlling territory. But perhaps another way to deal with this legally would be to say, well, as a matter of language, as a matter of textual interpretation, the phrase official capacity or person acting in official capacity is capable of bearing different meanings. And we say the meaning that was proposed by the respondent this morning in the context of an entity exercising de facto authority is one that is capable of coming within that concept of official capacity. The question about which meaning you choose, your lordships choose, we say that falls to be determined by object and purpose.
Thank you very much indeed. Thank you.
My lady, I will certainly be less than 30 minutes and maybe even 20, but I'll try and see what I can do.
See how you go.
In relation to the object and purpose of the Convention, both my learned friends for the respondent and the intervener draw attention to the preamble to the Convention, where reference is made to making more effective the struggle against torture. In response to that, we would say, of course, that that has to be in light of and in consideration of the scope of the Convention as set out in Article 1 of UNCAT, which states very clearly that for the purposes of the Convention, including the preamble, the term torture means as follows. And therefore, we respectfully submit, if we're right in our interpretation of public official and official capacity, then the object and and purpose of the Convention must be seen through that prism. In that regard, my learned friend for the intervener referred to the Belgian and Senegal case before the International Court of Justice. Of course, we don't dispute that torture is an erga omnes norm of customary international law, but it has to be observed that that case was being considered within the context of a very clear state official, the president of Chad, and all of the comments and the Belgium-Senegal case has to be seen through the prism of, in that case, they were dealing with someone who clearly was a state official, and that is what sets out the parameters of what the extent and scope of the Torture Convention. In response to some of the points that my learned friend for the respondent made this morning, in relation to the International Criminal Court Act at tab 2 MS 247, it's right to observe that despite its title, the International Criminal Court Act, it doesn't just relate to the crimes of genocide, crimes against humanity and war crimes in relation to the UK's responsibility or desire to prosecute people in this jurisdiction for those crimes vis-a-vis whether they were occurring in countries that recognise the International Criminal Court or not. If we look at section 51 of the International Criminal Court Act, which is at tab 2, section 51 at MS page 247 provides it's an offence in England and Wales for a person to commit genocide, a crime against humanity or a war crime. Subsection 2, B, outside the United Kingdom by a UK national, a United Kingdom resident or person subject to UK service jurisdiction. The linkage is to the person being a UK resident, which is given an expanded definition via section 67A, which is at MS page 249, where there's the residence in the United Kingdom includes those who have indefinite leave to remain, those who have made applications for indefinite leave to remain, and I won't repeat the whole list, but it covers a very wide category of people. The point is that the UK's jurisdiction to prosecute people for genocide, war crimes and crimes against humanity is in no way linked to whether the state where those crimes are alleged to have been committed has accepted the jurisdiction of the International Criminal Court or not. So the fact that the International Criminal Tribunal for the former Yugoslavia is coming to the end of its reign, with our respectful submission, has got nothing to do with the UK's position in relation to who it will prosecute in this country for crimes committed outside of this jurisdiction. The next point we would make is in relation to medical justices at tab 37. The significance of that case, we respectfully submit, is not just limited to what Mr. Justice Owsley says in that case about the UN Convention. It's that a branch of the state of this country, the Secretary of State for the Home Department, has applied an UNCAT meaning, has applied UNCAT and a meaning of official capacity in an inconsistent way with that being urged upon this court now by the respondent. The meaning applied by the Secretary of State for the Home Department and medical justices is important in that it sought to discriminate between victims of torture of a state and non-state torture. Paragraph 70 of the judgment Paragraph 70 which is at memory stick page 1161. We see there that this is a case in relation to Afghanistan and an individual who had been kidnapped and tortured by the Taliban. The Secretary of State for the Home Department conceded that the full Rule 35 report should have been treated as a level 2 evidence of torture with the EIG definition, which in effect is which extended beyond that in UNCAT and in the AARSG to include torture carried out by a terrorist group exploiting instability and civil war to hold territory. In our respectful submission, that if torture by the Taliban in Afghanistan, in the view and the position of the Secretary of State for the Home Department as adopted in the guidance that was to be applied by caseworkers, if torture by the Taliban, who held a significant amount of territory in Afghanistan, if that falls outside of the scope of UNCAT in the view of the Secretary of State for the Home Department, that in our respectful submission should be taken as a significant guide as to what the scope and extent of and meaning of Article 1 of UNCAT should be. We're not being critical of the Secretary of State for the Home Department in terms of how applied UNCAT in that scenario. We say it is right and is entirely consistent with how we say UNCAT should be interpreted, and it's entirely consistent, we respectfully submit, with the decisions of the Committee Against Torture that we looked at yesterday. The case of Elmi is of the Committee Against Torture is an exceptional case. It turned on the exceptional circumstances of there being no central government in Somalia at the relevant time. Now, why is that relevant? We submit that it was relevant in that case for this reason. Article 2 of UNCAT, MS page 274, Article 2.1 provides that each state party shall take effective legislative, administrative, judicial and other measures to prevent acts of torture in any territory under its jurisdiction. In the absence of a central government and in the absence of a government being able to carry out those functions as required under Article 2 of the Convention, there was an exceptional circumstance, and that was a key factor that the Committee Against Torture had to take into consideration when it was considering whether the Hawewi clan could be deemed to be falling within the scope and jurisdiction of Article 1 of UNCAT. But it was hinged also on the fact that the Hawewi clan was exercising, in the committee's view, state-like functions in a situation where there was no central government in the state as a whole. The Committee Against Torture decisions, we respectfully submit, have been consistent in their position that non-state actors outside the scope of the Convention, even if they control a significant amount of territory in the state, such as the LTTE, Sendero Luminoso, and the Taliban, even in such situations, they fall outside the scope of the Convention, and that has been the consistent position of the Committee Against Torture from start to finish. The first case that we looked at yesterday was GRB and Sweden. At General Comment number 4 of 2018, MS page 1475, footnote 1 in relation to the manner in which the Article 3 was to be interpreted, even as late as 2018, the committee still referenced and anchored its position in relation to the extent to which the Convention would extend to non-state actors, to its decision in GRB and Sweden. GRB and Sweden and the principles outlined in that decision are still the relevant way in which the committee will determine such cases. And of course, as the court will recall, in GRB and Sweden, the non-state non-state group concerned with Sendero Luminoso said to control a significant amount of territory. So even as late as 2018, from GRB and Sweden until 2018 with General Comment number 4, the position of the committee has been exactly the same.
But it's a pretty obvious proposition, I would have thought, that when Article 1 starts out, for the purposes of this convention, the term torture means, that in Article 2 and Article 3, torture means the same thing.
My Lord, yes.
So,
in relation to SS Netherlands and the LTTE, we respectfully submit there was and could have been no reason for the committee to take a different approach to that it had taken in SV and Canada and MPS and Australia, which all dealt with the LTTE, save to the extent to which, at footnote 10, reference is made to ELMI, SV and MPS. And we respectfully submit that when the committee is drawing a distinction and referring to the SV in Netherlands is at SS Netherlands at tab 53. No, that's not right. It's not 53. SS Netherlands. Sorry. SS Netherlands at paragraph 6.4. When the committee is referring to the question of whether a person who might risk pain and suffering inflicted by a non-state entity without the consent or acquiescence falls outside the scope of Article 3, unless the non-government entity exercises quasi-government authority over the territory complained of, to which the complainant would be turned. Footnoting to footnote 10 refers to the 3 cases of ELMI, MPS Australia and SV Canada. There's no logical reason for the committee to be adopting a different position in relation to the LTT in SS Netherlands and MPS in Australia and SV in Canada, unless there is a distinction between that and ELMI in Australia being the key feature of there being no central government. The only circumstances the committee is saying in which it is relevant and right to look at the extent to which a non-governmental entity occupies territory and whether an exercises quasi-government authority is in the circumstances outlined in ELMI in Australia, which is there being no central government, no central authority. And that, we respectfully submit, has been the position of the committee all the way through and is consistent. In relation to Kadic and Karadzic, at tab 69, it's right to observe at MS 1699 the very first page that Chief Judge Newman, on the top right-hand corner of 1699, the decision and the ultimate outcome in Kadic and Karadzic was, for the reasons set forth below, we hold that the subject matter jurisdiction exists, that Karadzic may be found liable for genocide, war crimes and crimes against humanity in his private capacity, and for others in his capacity as a state actor. And that, we respectfully submit, is significant. That was the ambit through which this case was being determined, and whether Karadzic could be said to be acting in his capacity as a state actor. So for the other violations, which included torture, the determining factor was whether he was a state actor and therefore immune from service. In relation to the reasoning in relation to that, there were 2 ways in which it was considered that there might be a case in which the appellants in Kadic and Karadzic might entitle them to bring a case against Karadzic for torture. One was the extent to which the Republika Srpska exercised was either a recognised or unrecognised state. The second way that Mr. Justice Newman got there was on page 1709, B, on the just after the section that deals with recognition or non-recognition, acting in concert with a foreign state. And at the bottom, it was concluded that the appellants are entitled to prove their allegations that Karadzic acted under colour of law of Yugoslavia by acting in concert with Yugoslav officials or with significant Yugoslavian aid. So that was one route by which it could be said that Karadzic was acting as a state actor by virtue of his acting under the colour of law of another state and acting in concert with them. And the second route is via the definition. If one looks back to page 1708, halfway down the page, the issue that Justice Newman was determining was the definition of a state in international law. And ultimately, he was ruling upon whether Republika Srpska, as an unrecognised state, could come within and fall within that definition. The words at the end of the bottom of the page, 1708, to the top of 1709, it is likely the state-like concept where applicable, some violations like official torture requires merely the semblance of the official authority. All of that is in relation to and part of the consideration of whether the Republika Srpska could be considered and come within a definition of state in international law, regardless of whether it was an unrecognised state by the United States. It wasn't seeking, and nor did it propose to, extend the meaning and scope of official capacity beyond that of states. Moreover, it's important to see Kadic and Karadzic in light of the decision of the Supreme Court in Sosa and Alvarez Machine. Tab 71, footnote 20, and I know you looked at it already when my learned friend for the respondent was taking you through it, but we respectfully submit it's important to look at what was said about Kadic and Karadzic when it was cited by the Supreme Court. It was cited to contrast the position with Talouran and the Libyan Arab Republic. It's interesting and important to note, we respectfully submit, that the extent to which the Supreme Court cited it was to show that there was sufficient consensus in 1995 that genocide by private actors violates international law. They did not go beyond that, save to identify genocide being carried out by private actors violates international law. And of course, there's no dispute about that, because as we looked at this morning, Article 4 of the Genocide Convention clearly does relate to, can be carried out and by private actors. That should be compared and contrasted to, as the Supreme Court does, to Talouran and the Libyan Arab Republic, in which it was held that there was insufficient consensus in 1984 that torture by private actors violates international law. Now, of course, I would accept that in 1984 the Convention Against Torture had just been, the drafting of the Convention Against Torture had just been drafted. I think at the time that Talouran and the Libyan Arab Republic was decided, it had still not been concluded. But that must be seen in light of the decision of Ali Shafi, which is at tab 68, in which at MS 1690, where the ultimate conclusion was, noting, as the Supreme Court noted at the bottom of page 1690, as the Supreme Court noted in Sosa, Judge Edwards observed in Talouran that there was an insufficient consensus that torture by private actors violates international law. In 2011, it remains the case that the appellants have shown us no consensus. The complainant does not state a claim cognizable with the jurisdictional grant of the Alien Tort Statute. So we would respectfully submit that the position in 2011 in relation to the Palestinian Authority was exactly the same in 2011 as it was in 1984, notwithstanding the fact that by that time the UN Convention Against Torture had been ratified and adopted by the United States of America. Finally, no, it's not quite finally, forgive me. The academic work of Professor Gator, tab 23, MS 559.
Sorry, the tab again?
Tab 23.
Thank you very much.
599.
599.
Sorry, forgive me, 559.
That's what I first wrote down.
Sorry, forgive me. At the bottom of the page, MS 559, in a nutshell, she states, the definition of torture enshrined in the 1984 UN Torture Convention simply reflects the willingness of contracting states to oppose, essentially by way of domestic criminal law, a specific behaviour, torture, but only when it is committed on behalf of or with the acquiescence of a state. That, we respectfully submit, is our position. And in those circumstances, we submit it is anything but manifestly unreasonable and absurd to adopt the position that we do. Now it's finally, in relation to the question on evolution of international criminal law as posed by my Lord Reed, it's important we respectfully submit to draw a distinction between the Torture Convention and the International Criminal Court Act, because the International Criminal Court Act, we submit, shows there's no, that under the International Criminal Court Act, section 50, which is at tab 2, section 50, MS 246, provides for the evolution of the crimes and the definition of the crimes, elements of the crimes under those contained within the International Criminal Court Act. Because if we look at section 50, subsection 2, meaning of genocide, crimes against humanity and war crimes, and it provides in interpreting and applying the provisions of those articles, the court shall take into account any relevant elements of crimes adopted in accordance with Article 9 of the ICC statute. So in contrast with the section 134 of the Criminal Justice Act, the International Criminal Court Act gives the courts in this country a route in which it can consider any developments in international law and the developments of the elements of crimes under international law in a way that it doesn't in section 134 of the Criminal Justice Act. So we respectfully submit that that is what makes it important to look at what the conditions were, both when the Convention was adopted in 1984, when the Act was passed in 1988, and particularly when the alleged offences in this case were said to have taken place, which is 1990.
I suppose you might, one way of looking at it might be to say that you have to construe the Convention consistently with the ICCPR, which is another major international convention, and and Article 15 of that prohibits offences, criminal offences under international law or national law, which were not offences at the time they were committed. So there's a no retroactivity principle at the international law level, which would be relevant if one were saying, for example, that evolving state practice or an emerging consensus had actually altered the meaning of, or altered the proper interpretation of the Torture Convention. And at the national level, you would say, well, the Human Rights Act and Article 7 of the European Convention would limit what the prosecution can do under under Section 134.
My Lord, yes. Yes, we're dealing with a criminal statute, and the words are, we respectfully submit, clear. And if there is to be an extended meaning, the only route to provide for such an extended meaning is to amend the statute. My lady, my lords, those are our submissions, save for two final things. It would be wrong of me to sit down without acknowledging the assistance of my two juniors in this case, Ms Cornelia and in particular Miss Eatwell, for all their extraordinary assistance with preparing our oral and written submissions. And secondly, without wanting to seem impertinent, if we can push for some indication as to when the judgment may be given in this case, and simply to raise the fact that the appellant is, of course, in custody,
Yes,
and
we understand
to raise that
too.
as an additional consideration.
Yes. Well, we'll do our best. That is, in fact, what we're now going to go away and do. And we always know that it's not only those who've been on their feet who've contributed to the wealth of helpful material with which we've been presented, and most of which we have already read, and we'll go away and read a bit more. But we recognise that this is an extremely important and sensitive case, and we will do our best to supply you with such answer as we feel capable of giving as soon as possible. Thank you. We'll now adjourn.